Hello, everybody, and welcome to the 2021 Landlord Seminar. I'm excited. My name is Brian Corrigan, and I'm the Law Director for the City of Lakewood. I'm excited to bring this to you remotely this year again. COVID-19 has forced us all to make dramatic adjustments to our lives. Hopefully, we have all made these adjustments and are practicing safe habits, including frequent hand washing, social distance, and the wearing of masks. We at City Hall are working diligently to abide by these practices and stay healthy. I encourage everyone to get the COVID vaccine shot as soon as you're able to do so. Together, we will get through this. City Hall is open for the operation of the Lakewood Municipal Court and for various city offices by appointment only. Masks are required prior to entry. While there is staff at City Hall, many continue to work remotely. Please call or email questions or concerns. We will address these promptly. This year's seminar is a required attendance in compliance with your housing license. At the end of this broadcast, a code will appear. You need to put this code onto the form available on the website to confirm your attendance here today. Also available on the city's website is a manual for landlords entitled Best Rental Practices. This is filled with a lot of good information and located at onelakewood.com. We have an exciting lineup of speakers tonight that include Judge Patrick Carroll of the Lakewood Municipal Court, Tanisha Hunter of the Fair Housing Center, Chris Parmalee of our Building Department, Lou McMahon, an attorney regarding EPA compliance with our storm and sanitary systems. With that being said, I'd like to introduce the Honorable Judge Patrick Carroll. Judge Carroll's been on the bench for over 30 years. He's very knowledgeable. He teaches many courses to both lawyers and judges throughout the state. We are honored to have him. He speaks on landlord-tenant issues and a variety of other issues as well, but tonight he'll be concentrating on landlord-tenant issues. So we're honored to have him. Judge Carroll, you have the floor.
Thank you, Director Corrigan, and welcome. I'm honored to be here. I know we do this every 6 months, and probably the next one will be around September, and I'm hoping it's in person. I want to talk, what I've done here is I've done something I haven't done in the past, is I'm breaking this down into two parts. This is part one on landlord-tenant law, and then there'll be another part in September. So anybody who sees this, while you may not be required, you're more than welcome to check it out again when we get to the other part, which will concern things like rent deposit, liability for security deposits for both landlords and tenants. Great not to wear a mask. It's a, I want to take a few moments to talk about this. There is also a book put out by Fred White. He's a former professor of law school at Cleveland State University. I know our library has it. It's published by West. I would advise any landlord who's going to get into the business or thinking about it, whether it's a double, a 4-suite, or a high-rise or whatever, it's a very good book, because I'm just going to touch on the highlights tonight. And many times, while it seems straightforward, there's a lot of complications to it. First of all, there's the Landlord-Tenant Act. That is 5321 of the revised code. That sets out rights and duties and responsibilities of both landlords and tenants. It applies to residential property only. Now, this is a major change that occurred in 1974 in the state of Ohio. And just to give you an idea about the how big of a change this was, property law is very slow moving. And the most recent change prior to 1974 was the statute of wills in 1540 under Henry VIII. This is a very major change in the law. What it does is it sets out statutory responsibilities that cannot be modified by either lease or contract. And again, this applies to residential property only. It does not apply to commercial property. The landlord-tenant relationship, that's the most important thing, because this chapter 5321 of the revised code does not apply until there's a landlord-tenant relationship between the parties. That happens when there is delivery of the possession of the rental property and execution of the rental agreement. Both must apply. In other words, the tenant, prospective tenant, must have actual occupancy, sole and exclusive, to the exclusion of the landlord. A tenant who applies, puts down a rent deposit, and is told by the landlord, yes, you can have, we've approved you, you can have the apartment as of March 1, there is not a landlord-tenant agreement there, even if they signed it, because the keys have not been handed to the tenant. Both of those are required. And this gets into it, let's say if a tenant puts down a first month's deposit of rent and said you'll refund it if you don't get the property, they do get the apartment, and then they're told, well, I found another place, I'm not going to move out, our house is ready, I just got to transfer. They would be entitled to get that rent deposit back, because there's no landlord-tenant relationship at that point. Again, in certain cases with security deposits, there could be a double damage amount if the landlord refused to do it. That wouldn't apply here, because of that only applies when there's a landlord-tenant relationship, and there isn't. Now, a landlord-tenant relationship can be in writing or verbally. My advice, if you're a landlord or a tenant, get it in writing. Here's why. Things go bad once you get into the relationship from time to time. What I want to point out that I think there's more renters than there are homeowners last time I checked in Lakewood. And last year we had about 500 landlord-tenant cases. That would be rent deposits, small claims where a tenant is suing to get back the security deposit, forcible entry, eviction cases. So the vast majority of the landlords and tenants are doing the right thing. The landlords are maintaining the property, the tenants are keeping it in good shape, paying the rent, moving out, not destroying the property when they leave. We get the problems. That's what the court is for. And when those problems do occur, you want to have a document you can go to. The last thing you want is, well, I thought they were supposed to do this. No, I heard you say that. So it's much easier to put it in writing. Hopefully it doesn't go wrong, but if it does go wrong, you can say, well, under paragraph 22, you were supposed to do this, or you're supposed to do that. So it's always better. And I know many times, you want a landlord or a tenant, you want to start out in a good relationship with the other person, put it in writing, nothing to hide, always a good idea. So a rental agreement can be oral or written. It doesn't have to be, as long as it establishes and modifies the terms, conditions, rules, regulations concerning the occupancy, again, of the rental premises. What is barred by that is anything that there can't be a modification of the duties except agreed to by the tenant. No confession of judgment, which would be a cognitive note. A party cannot agree for the other party to pay their attorney's fees. These are improper. No agreement to exculpate, or limit the landlord's liability on such liability, and no agreement to modify, which we're going to talk about in a few moments, the landlord's statutory obligations under the law. If there is a problem with that, if it's an unconscionable agreement, if it doesn't comply with the law and the duties, then the court, when they get this agreement, when you're in court, has the option of either severing it completely or reforming it to the what the court feels the parties did agree to. So better to put it in writing. An example of something that would be unconscionable is a unreasonable late fee. If the rent is $800 a month and there's a 5% late fee, it's kind of like the interest that they would have to pay. If it's $20 a day with no limitation, so it could go into the thousands, that would be unconscionable, and the court will strike that, even though it's in the agreement, even though the tenant agreed to it. It just because it's in writing doesn't mean that it's valid. So if it basically, that most of the time we see an unconscionable issue is when it involves late fees. If you ask for too much, you're probably going to get nothing. So again, and we hear the landlord say, but he signed it. An agreement to say any damages that you move out, we have a schedule of damages, and the tenant agrees to pay $100 to paint each room. Tenant agrees to, if there's a schedule, that is not proper, and even though the tenant agrees to it. So again, what's unconscionable, the court can then refuse to enforce the rental agreement, can enforce part and with the remainder without the unconscionable clause, or limit it to avoid an unconscionable result. In other words, redo it. Now, what is rent? Rent is usually money. That's what we talk about. If it's an $850, to use that example again, you pay that on a monthly basis. If there is late rent, and the landlord brings the accepts late rent on a regular basis, that can modify the lease. So if rent is due on the first of the month and the tenant continues to pay the rent 4 or 5 days later, and you accept it without doing anything as a landlord, you have modified that lease. You can't say, well, we accepted it late for November, December, January, February, and on March 1st, you didn't pay it on time, so we're going to start an eviction process. The landlord modified that by accepting rent. If you want to go back to the first of the month is when it's due, you must put something in writing telling the tenant, up until now, you've been paying 4 or 5 days late, and we've been tolerable about that, but at this point, we insist on enforcing the terms of the lease, and that includes payment due on the first of the month. Then if they don't pay it on the first of the month, if you want to start an eviction proceeding, you can do it. But if you have a continually accepted rent, then you have effectively modified the agreement, and that could result in the case being dismissed. Rent is usually not prorated. If it's a month-to-month tenancy, as opposed to a one-year rental agreement by lease or otherwise, and a month-to-month, and we'll talk about that in a few minutes, is that either party can terminate it after giving notice prior to the beginning of the next term. So if the next term begins on March 1st, you give notice as a landlord or tenant that you want to move out. If the tenant stays over into the second day of the month, they owe for the entire month unless the agreement provides for prorating of the time. So if you're a landlord, keep that in mind. If you're a tenant, keep that in mind, because we see that all the time. The tenant says, well, I stayed in February, for example, for one week. That's 1/4 of the month. I only owe 1/4. No, as of 12/01 on the first day, you owe for the whole month, unless both parties agree to that. Rent for services, I would strongly advise never to do that. That causes a lot of problems. Especially for landlords. You look at what we've had in the last 3 weeks. You say, well, tell you what, you shovel the snow and I'll take $100 off your rent every month. Okay. A week ago it was 10 degrees. Today it's 45 degrees. There's no snow. There was snow. Many times it might snow and you might have to shovel the snow 3 or 4 times even in one day, depending on the snowfall, and may not have to do it again. How do you, the tenant says, well, I'm not, I did it once for that month, so I'm knocking $100 off my rent. Landlord says, no, that's not enough. You only did it once. Or the tenant says, hey, I had to do it 5 times in one day and 3 times another day. That's not fair. It should be $200. You get into arguments that way. The other problem you have is you're mixing relationships. You got a landlord-tenant relationship between the parties. Now you have an employee-employee relationship. If you have the tenant show the property, if it's a double or a 4-suiter, and say, well, the tenant will let you in suite 5, and he'll show, I guess you wouldn't have suite 5 and a 4-suiter, but He'll show you around. Be very careful, because he is now the landlord's representative. If you're the landlord, be very cautious. If that tenant makes some type of improper comment, racial, sexual, any type like that, you could be sued as the landlord, because that person is now your agent. If they say we don't rent to gay, lesbians, you could be sued for that. If they make some type of racial comment, you could be sued for that. So be very, very careful when you do that. As I said, there's obligations that are set out by the landlord that cannot be modified. They're set out by statute. Basically, the Ohio Revised Code, the state of Ohio has written part of your rental agreement, and this must, whether it's included or not, it's automatic. Obviously, the obligation to maintain the premises, to comply with all building and housing codes, to make repairs. Common areas must be safe and sanitary. Maintain electrical, plumbing, sanitary, heating, ventilation, and air conditioning, and appliances. Now, if you notice, it says number 2, make repairs. Number 4, maintain. So it's not only if something goes wrong, but also to maintain it. Those are, and there's been numerous cases on that, and the difference between that language that the General Assembly chose. For appliances, a landlord does not have to put appliances. Most apartments have stoves and refrigerators and things like that. If the landlord does provide that, that's part of the rent. That's part of what the tenant gets, and the landlord has the obligation to maintain it and replace it if it breaks down, if it has to be replaced. Even if you put in there, this is an old stove and I'm going to put it in, but if it breaks, you got to buy your own. No. If it's in there, if the appliances are in there, the landlord has the requirement, the obligation to do that under law. Number 6, supplying running water, reasonable heat, and hot water. The landlord does not have to pay for that. The landlord has to supply it. We're talking about a hookup. That's all. The landlord can put in there that the tenant owns is required rather to pay for the hot water. If you do that, I would strongly suggest that there's a meter to each individual suite if it's more than one suite, if it's a double, a 4-suiter, or whatever. Otherwise, if you start saying prorating it with the other tenant has family over, you get into an argument about they use more hot water than I did. I would strongly advise you not to do that unless you have a separate meter on each one. Reasonable notice to enter the premises. Reasonable notice is generally 24 hours, but that may change depending on the circumstances. You get a call, obviously, from the downstairs tenant that there's water leaking because the upstairs tenant left the bathtub running and went to work and forgot about it, and there's water leaking. You don't have to call the upstairs tenant to work and say, well, we're going to come over tomorrow to shut off the water. You can go in there, that's an emergency. So reasonable notice is usually 24 hours. You've got somebody, if you're a landlord, that's going to come and do repairs, do bug checks, things like this. You give notice so the people know that they're coming in. And if you do that, normally 24 hours, there's going to be a handyman coming around to all my rental property on next Monday. They're going to check out your apartment. If you have any minor repairs to do, let us know and they can address them, things like that. Now, there's also tenants' obligations. These are set out by the statute, but unlike the landlord, these can be assumed by the landlord or waived by the tenant by agreement of the landlord. So landlord's obligations can never be changed. Tenants' obligations may be changed. That's up to the landlord. So if a landlord puts any of those obligations, and that's as follows, and again, the code section is there, 532104 for the landlord, 532105 for the tenant, and it makes sense what it says. Keep the premises safe and sanitary. Take the garbage out. Keep the plumbing fixtures clean. Hair in the drains, things like that. Comply with all health and codes. You see this a lot with extension cords and surge protectors that are going from, a lot of the buildings are old and you're running a lot of electrical devices from something that could cause a problem. Especially if they're cheap electrical cords, you can feel them. They're warm. That means there's a potential fire. Using the electrical and plumbing fixtures properly. There's also a duty of the tenant to notify the landlord if they're not working. If a socket is out in the living room and they're saying, well, we're just going to run everything through the bedroom and not tell you that the electrical socket is out. There's a drip in the bathtub. The tenant's got the obligation to tell the landlord right away about that, because otherwise it's going to destroy the porcelain or the finish on it, and is just going to get a whole lot worse. So prohibit other people on the property from damaging the property as well. Again, when you talk about do not disturb the enjoyment of the others, landlord has reasonable access to the property. That goes down to a balancing of the rights and obligations of the parties. The landlord is the owner of the property. They want to make sure that their property is in good shape and being maintained. The tenant has a right to privacy. So those things have to be balanced. And that goes back to the reasonable notice that we talked about a few minutes ago. If there's going to be any change to the property, painting, for example, we get more cases involving painting, where the tenant has the obligation to leave the premises in the condition that they found it. You, as a tenant, want to paint the property. You go in there and the living room's beige and you want to paint it blue, you have to get the landlord's permission. Permission to paint does not necessarily mean that it's okay to keep it that way. So in other words, if a landlord many times will give the tenant the Sherwin-Williams, the little bits of different colors and say these are the acceptable colors, that doesn't necessarily mean that it's got to be that does not have to be returned to the original beige or light blue or green or whatever the color was. So even though the landlord gives the tenant permission to paint the property, doesn't mean that it doesn't have to be changed back. Again, tenant has the obligation to maintain the rental premises. I appreciate my son's giving me the picture of his college dorm. Quiet enjoyment of the other tenants. That could be grounds for evicting as well. The other tenants don't want to hear a lot of noise and fights and things like that. The landlord's duty and or claims for breach would include eviction of the tenant, monetary damages, and attorney's fees. We're going to talk about eviction, which is forcible entry and detainer. And again, first of all, there has to be a notice of termination if it's a month-to-month as opposed to a lease, or it's a violation of the tenant's obligations, statutory obligations that we talked about before. Those are the obligations listed out in 5321.04. If there is a violation of those statutory obligations, the landlord has to give a 30-day notice, and it has to be specific about what the violation is and the tenant's obligation. The tenant has a right to cure that. So the tenant is putting bottles outside of the apartment, and you say, no, they should be taken down the hall and put in the recycling, and you give them notice that they haven't done that. You're going to evict them for not doing it because you don't want trash out in the hallway. The other neighbors are complaining about it. If the tenant says, geez, I'm sorry, it won't happen again, and they cure it and don't do it, then that would take away the reason for evicting them. 30-day notice is not required for non-statutory violations. What's that? Usually non-payment of rent. That's the non-statutory obligation. It's a 30-day notice. Only the General Assembly could come up with a 30-day notice that could be 60 days. Why? Because the 30-day notice begins prior to the first day of the term. So if you're a landlord right now thinking about evicting your tenant, you've got till February 28th to give them written notice. What happens on March 1st? It starts at the next term, which is April 1st. So that would be a 61-day notice before you could begin the eviction proceedings. So it's the balance of the current term plus the next term. It's not 30 days. So if I give somebody notice as a landlord today on Today is the 24th of February as we're doing this. It doesn't start on March 24th, it starts on April 1st. The exception to that obviously is illegal drug use. All right, so you give them the 30-day notice as a landlord. Now you want to pursue the eviction proceeding. What do? First, you have to give them second is a 3-day notice. Regardless of whether a 30-day notice, and I said before, non-payment of rent, you don't have to do a 30-day notice. You always have to do the 3-day notice. It's mandatory. If you don't do it, we have to dismiss the case. There is mandatory language in 1923-04 of the revised code. There are very few places revised code where the General Assembly says, this is what you must say. It must be in writing. It must be conspicuous, bolded on your computer when you give it to them. You can download, there's notices that have been appropriate. That's separate in addition to the 30-day notice. You have to wait for the 30-day notice to expire. They don't run concurrent. And then the 3-day notice after that 30-day notice is done. So you want to evict somebody starting today, you give them the notice between now and February 28th. The 30-day notice, if it's applicable, runs for the month of April or March rather. They haven't moved out on April 1st, then you can give them the 3-day notice. And then after the 3-day notice is expired, then you can bring your case to have them evicted. But again, use the statutory language. If you don't use that language, and every once in a while, we get a landlord that says, you know what, I made up my own notice. Without that statutory language in it, we must dismiss it. All right. Then you, on the 3-day notice, intervening Saturdays and Sundays are included, but the day of service is not. So if I serve somebody on a Monday, Monday doesn't count. Tuesday, Wednesday, Thursday counts. You could bring your complaint for eviction on Friday. I served them on Thursday. Thursday doesn't count. Friday, Saturday, Sunday counts. You can bring the eviction action on Monday. I serve them on Saturday. It's Sunday, Monday, Tuesday. You bring the eviction action on Wednesday. There's no time limit to that. You can go more than 3 days, but it's minimum 3 days, not including the service. You can serve it to the person by certified mail, actual delivery to the tenant, or leaving it the tenant's usual place of where they live. I would say, certified mail. Good luck with what we're getting from the post office nowadays. Actual delivery is a better place, or the tenant's place of abode. Again, if you're going to do that, you can put it on the door, but it must be the door of the premises. So if it's a 4-suite or a double, not the outside door, but the actual door that goes into their specific suite that you must put it on. And then after the 3 days, you can go for, okay, so now the 3 days have run, they still haven't moved out. You come down to court, you file your complaint for eviction, and the court will issue summons. There are 2 mandatory ways to do it. You must first do it by ordinary mail, and you would give instructions as the plaintiff, as a landlord, and either personal service, which you can serve the person by delivery to the tenant, handed it to them, delivery to the person of suitable age. You can't give it to their 5-year-old, say, here, give this to your mom. That's not somebody of suitable age. It has to be somebody who has the understanding that they will provide it. Teenagers, yeah, most of the time, who knows? Usually somebody over the age of 12, you're probably going to be all right. Make sure the person lives there. It's not the cleaning woman. Or somebody doing repairs and you hand it to them when you drop it off, or post it at, again, at their conspicuous place, or with the person of suitable age who's not at the premises. You can hand it to somebody like that. You're walking out, the husband, the wife is coming back, one of the kids, you can hand it to them outside, or again, on the door, or certified mail. So it's got to be either number 1 and/or 2, A, B, C, or 3. So always 1 and then a pick of the others, but it must be both. Let me advise you, we've had issues with certified mail with COVID. Mailmen postal workers are now not actually getting a signed document. They're putting COVID-19 and I'm leaving it at the door, it's not clear whether that's good service or not. So I would be very, very careful about certified mail given these times, because we've had a lot of delays in these cases. Best is delivery. If you're nearby, you live nearby, drop it off at the person, put it on their door, just like you did the 3-day notice the week prior. All right, so then you file your complaint. In the complaint, you must put in the termination of tenancy. You know, why, you know, if they're required the 30-day notice, not all do. You gave them the 3-day notice. My advice is attach a copy of the 3-day notice of complaint. What's the grounds? Why are you seeking to have them evicted? And that you cannot accept rent. Acceptance of rent after the 3-day notice, if it's future or current rent, is grounds for dismissal. It must be dismissed, because if you accept the current rent. So, person didn't pay February rent. They didn't, and they don't pay March rent. You start on March 1st to have them evicted. On March 15th, they offer you the back rent for February and March. If you accept both of them, you must dismiss, because it's current or future rent in March. If you say, well, I'll accept, they only offer you 1 month's rent, and if you say I'll accept it, but I'm applying this to the back rent in February, not in March, then you can do that. If they say I want this to be current rent and you accept it for March, even though they owe February rent, you must it has to be dismissed. Back rent you can accept, current future rent you cannot, unless you want to dismiss the case. Now, on September 4th, the federal government threw a curveball at us. Originally through the end of the year in 2020, it's been now extended to March 31st. I know under the Biden administration, they're doing other things for relief of tenants. This is a CDC moratorium. It applies to all residential property. If you remember from last year, there was a CARES Act that put a moratorium for rental property if it's covered by a federal mortgage or under Section 8 housing or HUD, things like this. This applies to all residential property. It is limited, though, to non-payment of rent. If there's other reasons to evict them, they're causing fights, there's noise, then you can have them evicted for that reason. They're destroying the property. It does not prohibit the filing of the complaint. You can still file the complaint for eviction, but the court may be limited in what they can do and may have to stay it. What does a tenant have to do? They have to show 5 things. They have to show that they've made best efforts to obtain government housing, that they were eligible, not received, but eligible to receive that stimulus check that came out last year, or the current stimulus check, that they're not able to pay the rent due to a substantial loss in wages, income, or hours. So if they're able to pay the rent and just not paying it, if there hasn't been any reduction in their employment, or they didn't incur any extraordinary medical costs, non-payment of rent alone isn't enough. That they made best efforts to make partial rent, and that there's no other available housing options, and it would need to move into a shared residence. This gets back into the situation that they talk about closed quarters because of the quarantine, because of COVID. So there's a document, the court has it, it's online, that they have to fill out. The tenant has to fill it out. The tenant is supposed to serve it on the landlord. Many times they file with the court. If they do that, either the landlord has the option of having requesting a hearing on it or agreeing. If you're a landlord and you agree that this happens, then we can't do anything until after March 31st right now. If you wish to dispute it, we'll have a hearing. If the court finds that they do comply with these 5 requirements, we have to stay it until March 31st. If they don't comply with it, then we can proceed with the eviction proceeding. And again, this is just for non-payment of rent. I would advise you, as I said before, there's probably going to be changes in this area between now and March 31st. As we're getting these, we're going to post them on our website at the court, so please check that as well. This is not the affirmative defense. This is not some affirmative defense is normally something that if you don't raise it right away, it can be waived. The landlord could come in and have a hearing on it, and the tenant doesn't show up. The magistrate says, well, they didn't pay the rent. We're going to order them to be out in 10 days. 9 days later, the tenant files this five-part declaration. We have to stop the proceedings if it's done before the move out and have a hearing on it. So it's not waived if it's done before the move out. That if the move out has happened already, then it's too late to do anything about it. The tenant is again required to submit the form. It's a sworn statement. The court is required to have a hearing. There are criminal penalties for false statements for either landlord or tenant. In other words, let's say the tenant served on the landlord and the landlord didn't tell the court and proceeded with an eviction proceeding. There could be a criminal penalty, and it could be also grounds for vacating the order of eviction. So many times it might go right to the landlord, and the court doesn't know about it. The landlord's then got the obligation to tell the court that this was in fact filed. If you're a landlord, or talk to the tenants. What is the reason for non-payment of rent? Is it something that they just don't want to pay the rent? Think about the possible quarantine, which could be grounds for denying eviction. If someone's got to be quarantined for 10 or 14 days, we can't order them out in that 10 days, which is what the statutory time is. In our court, I know a lot of other courts are doing this. We have pretrial conferences and mediation to see if we can't get the parties to work things together, work out a payment plan. We've been very successful with a lot of the major landlords in Lakewood, where you work out a payment plan to say, look, you pay as a tenant 25 or 33, a third, a quarter of the rent. We'll defer the balance of it for now. You still have to pay it. We'll waive late charges, and you pay this down the line, and we'll keep it there. If you got a good tenant and you're a landlord, you want to keep the tenant there and try to work with them. A landlord may qualify for mortgage forbearance. There's other rent resources such as local churches or charitable organizations, and contact them as well. The Ohio Grant Relief Fund just came out with a, one moment, on February 10th, I believe it's a $100 million in rent release that is going to be offered throughout the state of Ohio. If you Google Ohio Home Relief or Ohio Home Relief Grant, put those words in, it'll direct you to, it's a cumbersome website. I understand, I've been through it, and then it'll bring you to the agencies in Cuyahoga County, and there might be rent relief for the tenants. As a landlord, it might be worth it to check it out too, because many tenants are unsophisticated. Quite frankly, if you can help the tenant get the rent from the government that will go into ultimately in your pocket, it's a win-win situation. So these are things to do. Kind of think out of the box right now. And I understand that, you know, these are different situations. You have to look at, is it a double where you may be, as a landlord, is living next door to the tenant in the same structure, as opposed to a four-suiter where the landlord is not living at the premises. It's easy to beat up on landlords. The vast majority of landlords in the United States are small businesses. Many own only 2 or 3 or 4 suites. They're not the big major landlords that we think about with the high rises and things like that. Many times a landlord also could have been laid off or had reduced hours, and they're depending on this rent to pay their mortgage or their income. That's their main source of income. So I understand that, but the main thing to do is try to work together on it as well. One final thing I want to talk about is tenant screening. There are commercial screening services available. If the landlord does not have a screening system, you can check municipal courts. Every case in a municipal court has a letter designation, alpha designation. Landlord tenant cases are G, CV, civil, G, landlord. A is felony, B is misdemeanor, C is OVI, drunk driving, D is traffic, ... G is evictions. So look up the person's name, see where they've lived. We have it in Lakewood, Rocky River, Parma, Berea, Cleveland. You can look up the names. We have every case that's been through this court since 1986. You can go home tonight and look up all your neighbors and see who's been in trouble here, and take a look at it and see, and talk to them if they, if they've been, see if they've been evicted multiple times. I always say stop at a bank when you get into a bank and get a credit card application and take a look at it. All the information that is in the credit card will be helpful. You can, if they've moved in the last couple of years, ask them why. Maybe somebody's going through divorce. Maybe they just got transferred here and they stayed in one place for a year and moved on after that once they got the lay of the land in the Cleveland area. Finally, records that are sealed. If a record is sealed, it will not be on that website that I mentioned. It's taken off, it doesn't exist. That doesn't mean you can't find it if you Google it or use some other search engine, but please do not deny a tenant an application just because they have a criminal conviction, especially if it has been sealed. So if it's not on the court record, that means it's been sealed. It doesn't exist. It is taken off. If a case has been sealed or expunged, a criminal conviction, that's a statement by a judge that there has been a hearing, that the judge has determined that that person has been rehabilitated after a certain period of statutory time, could be 1 year, could be 3 years, depending on the circumstances, and that that person is no longer a risk to the community. So you go on and you Google somebody's name and it comes up at the day at a prior drug conviction, prior theft conviction, and you go on in Lakewood, you go on to Lakewood, you can't find it, it probably means it's been sealed. And if you deny the person a rent application for that, you could be putting yourself in jeopardy because that case no longer exists. And it's not valid grounds for turning the tenant down. So I want to warn any landlord about that. I think that's our last slide. I appreciate the time, and I hope I didn't go too far over, and turn it back over to Director Corrigan. Thank you.
Thank you, Judge Carroll. Lots of good practical information there from a guy who's had over 30 years experience and who deals with these cases every week in his courtroom, and has heard every reason and every excuse, and has seen every situation of which you've tried to summarize for us. So thank you so much for your presentation here tonight, and I appreciate it. Our next speaker here tonight, who I see on the screen, hello Tanisha, is Tanisha Hunter, and Tanisha Hunter is the Director of Education and Outreach at the Fair Housing Center. And so Tanisha, thank you for being here tonight, and the floor is yours. Thanks.
Thank you so much. I appreciate you having me tonight. Great. And so I just want to start by giving some information about the Fair Housing Center. Our mission is to protect and expand fair housing rights, eliminate housing discrimination, and promote integrated communities. So we are a nonprofit organization serving Cuyahoga County, and we drive our mission by some core services that includes direct advocacy. So that may be walking a consumer through some fair housing complaints, complaint investigation, so investigating into those complaints, enforcement, research. We have a phenomenal research team that puts out several different publications regarding fair housing concerns, and then education and community engagement. So going out into the community, just like today, and letting landlords, tenants, and municipalities understand their fair housing rights and their obligation to fair housing. So fair housing is a civil right protected by federal, state, and local laws. So just like zoning codes and building occupancy codes, laws, those need to be followed. fair housing law needs to be followed as well. And there is a distinction between federal, state, and local laws as it relates to protected classes, and we'll talk about that in just shortly here. So the goal of the Fair Housing Act is to eliminate housing discrimination, and then also to promote residential integration and undo the effects of prior discriminatory policies and practices. And this is also known as affirmatively furthering fair housing. So why is fair housing important? Well, where you live matters. Where you live is just not where you lay your head at night. It impacts your life outcomes. Housing impacts access to quality schools, access to healthy foods, whether or not you live in a food desert or if you have grocery stores close by, access to jobs, whether or not you have access to transportation to obtain those jobs, and then also access to healthcare, whether or not you have local clinics in your neighborhood or if you have to travel far to get to a hospital. Where you live also impacts your life outcomes. It's been said that your zip code is a better determinant of your health outcomes more than your genetic makeup. It also impacts your upward mobility. So again, your access to economic resources. And then also your exposure to environmental hazards such as lead and things of that nature. So where you live is certainly important. And so that's why it's important that individuals have the option to make choices for their fair housing without discrimination. So to start, we'll talk about protected classes under the Fair Housing Act. The Fair Housing Act was signed April 11th, 1968. And so we'll go over the protected classes included in that. So on a federal level, there are 7 protected classes under the Fair Housing Act, and that includes race, so whether or not a person may identify, for example, as either Black or white, color, and that can be intra-race, meaning that someone of the same race may discriminate against another person because either they're light skin or dark skin, national origin, religion, sex, familial status, and then disability. We'll go a little bit further into sex, familial status, and disability to give some further clarification on those protected classes. So that's on a federal level, but then here in Ohio, there are also additional protected classes. So in Ohio, ancestry and military status are included in Ohio's fair housing law. So as I stated before, fair housing laws are on the federal, state, and local level. And so some additional protected classes that you may see in local fair housing ordinances may include sexual orientation, gender identity, gender, marital status, parental status, source of income or how someone pays their rent, creed, occupation, physical characteristics, ethnic group, age, or association with a protected class. And so in Lakewood, there is a very comprehensive fair housing law that includes some of these additional protected classes as noted. So in the city of Lakewood, sexual orientation, gender identity, gender, marital status, creed are all included as protections under a fair housing law, as well as physical characteristics. So to talk a little bit more about protection on the basis of sex, because there's some additional items to consider when talking about protections under the basis of sex. So in that respect, it prohibits discrimination due to one's sex, so whether or not a person identifies as male or female, one's status as a victim of domestic violence, so that's regardless of sex. We know that a victim of domestic violence can be either male or female. However, women tend to be domestic violence victims. Then also one's nonconformity with sex role stereotypes, including sexual orientation and gender identity. And then also sexual harassment is included in that as well. And so some new news regarding sexual orientation and gender identity is that President Biden just recently signed an executive order that addresses the Supreme Court decision under Bostick versus Clayton County, which held that sex is discrimination. And so through that executive order, HUD, the Department of HUD, will now be taking cases under fair housing discrimination that includes sexual orientation and gender identity. And through that executive order, it has been affirmed that sexual orientation and gender identity is included as a protected class under the basis of sex. So while these aren't explicitly listed in the Fair Housing Act on the federal level, that executive order has affirmed that sexual orientation and gender identity is included. For sexual harassment, it's important to note a few things. So quid pro quo, also known as this for that, is included under sexual orientation. So for example, this is when a landlord might try to offer someone something in order for them to not pay their rent. So say, for example, a landlord says, you know, I will give you half off your rent if you maybe go on a date with me, or if you have some sort of sexual advances toward a sexual encounter with me, I'll give you your rent for free. This is prohibited under the Fair Housing Act. Also with sexual orientation, that also includes hostile living environment. And so this is when a housing provider, his or her employee, people who work in their office, and etc. This is when they encounter an act that is either so pervasive or substantive that it makes someone uncomfortable in their living environment. So say, for example, a landlord perhaps every time a tenant goes to pay their rent, they're making advances at that person. Or every time they come to do a maintenance repair, for example, a home maintenance repair person, every time they come into the home, they're making some sort of advances to that tenant. That may make a person so uncomfortable that it changes the tenancy for that person. And so under those circumstances, under hostile living environment, that could also be a violation of the Fair Housing Act. Now to talk a little bit more about familial status and the definition. So this is the presence of children under 18 living with a parent, legal custodian, or designee, or someone who is pregnant or in the process of securing legal custody of a person under 18. And this also includes foster parenting and adoptions. There is an exception, and this is included under the Housing for Older Persons Act. And this created an exemption for familial status for qualified senior housing. So in certain circumstances, if there is a senior building that requires maybe someone only 55 and older or 62 and older, in those circumstances, those buildings can say no children allowed. But otherwise, it is a violation of the Fair Housing Act to say no children allowed. So some familial status common violations, setting maximum occupancy lower than what is the actual standard. Okay, allowed by the occupancy code. Reasonable local standards are okay. Mixed gender living is also okay, even in subsidized housing. And so there's a lot of misconception about mixed gender living. So say, for example, if a tenant, especially if they are on like the Housing Choice Voucher Program, formerly known as Section 8, if they are looking to rent a house with their 2 children and it's only a 2-bedroom apartment, and the tenant would like their son and daughter to live in the same bedroom, that is allowed. There's a big misconception that that is not allowed, but it is. And so in the absence of an occupancy code, the general guidelines is typically 2 people per bedroom. So if you're a landlord and you're setting a maximum occupancy lower than the occupancy code, that can be considered a violation under familial status. So for example, if you want to, of course, check your local occupancy codes. But for example, if there's a 3-bedroom apartment and you're stating that only up to 2 or 3 people could live in that apartment, that could be a violation because it's steering people with families away. So again, 2 children of the opposite sex will not be required to share a bedroom, although they may do so per the family, and that's through the HUD Public Housing Occupancy Guidebook. And again, just a reminder, familial status exemptions are allowed for qualified senior housing buildings. More on some of the protected classes. So disability, and disability has a specific definition under the Fair Housing Act. So it is a physical and or mental impairment which substantially limits one or more major life activities. And so in this instance, for example, I wear contact lenses. That doesn't substantially limit my major life activities. Also included in that is a record of having such impairment, being regarded as having such impairment, so how someone may perceive someone else. So for example, if a landlord maybe sees a tenant walking a certain sort of way and assumes that they have a disability. And then this also includes people associated with or residing with a person meeting said definition. So which disabilities are covered? So some examples: chronic mental illness, hearing, mobility, and visual impairments, cancer, AIDS, HIV, developmental disabilities, alcoholism or past drug abuse. The Fair Housing Act, however, does not protect current illegal drug users or anyone who poses a direct threat to the health and safety of others or causes substantial physical damage to the property. And so we will go a little bit further in depth about additional protections for people with disabilities. It's important to note as well, we get some questions about marijuana use, seeing that marijuana is allowed for medicinal use in Ohio. It's still illegal for recreational use, but it is allowed for medicinal use. We get questions about marijuana. Marijuana is still a Schedule 1 drug under the federal law, and we have it's yet to be seen any cases in Ohio that addresses this issue. So we don't have clear answers on that just yet, but it is a topic that's emerging. So more for additional protections and special concerns for people with disabilities. So the Fair Housing Act was amended in 1988 to include disability as a protected class. And along with that came some additional protections for people with disabilities. That includes reasonable accommodations, which equal a change in policy, and then also reasonable modifications, which equal a physical change. Then there are also new construction requirements for buildings built for first occupancy after March 13th, 1991. There are 7 accessibility features on those new construction, and that includes an accessible building entrance on an accessible route. So for example, this means, can a person using a wheelchair perhaps get from the parking lot into the building? Also included in that is accessible and common public use areas. So can a person using a wheelchair get to a common area, such as a lobby or swimming pool or picnic area? Usable doors, usable by a person in a wheelchair. So are the doors wide enough for a person in a wheelchair to get through? Also included in that is accessible route into and through the dwelling unit. So is the entrance into the apartment wide enough to accommodate a wheelchair, or can a person using a wheelchair get from one place to another without encountering any narrow doorways and have to worry about getting stuck? Light switches, electrical outlets, and then also thermostats and other environmentally controlled are in accessible locations. So this means, are light switches and temperature controls low enough to be reached by a person using a wheelchair? Then also reinforced walls in bathrooms. And this is specifically for when individuals are trying to have grab bars installed. Is that wall going to hold up a grab bar if it's installed? And then usable kitchens and baths. And so this, for example, would be, can a person in a wheelchair easily access the kitchen sink or the bathroom sink? So those are the 7 accessibility features on new construction. And again, this is for construction built for first occupancy after March 13th, 1991, that would require these new construction features. So more about reasonable accommodations. Again, it's a change in policy or procedure when it's necessary to afford equal opportunities to use and enjoy the dwelling. Can require proof of covered disability if it's not readily apparent. So you as a landlord, if you have a tenant requesting a reasonable accommodation and the disability is not readily apparent, you can require proof. Changes must be related to a disability. And then also, it doesn't have to be granted if it would cause undue financial and administrative burden on the landlord, or would be a fundamental alteration of the provision of housing services. And a reasonable accommodation request can be made at any time. So it doesn't have to be made prior to the tenant moving in. It doesn't have to be made 6 months into the tenant living there. Whenever it becomes necessary, a reasonable accommodation can be made. So some examples of reasonable accommodation requests includes allowing service animals despite a no pet policy. So this is a big one. Some individuals may have pet policies at their homes, may try to charge additional fees for pets. Service and emotional assistance animals are not considered pets under the Fair Housing Act, and charges cannot be given for pets for individuals with service animals and emotional support animals. Also, breeding restrictions are not viewed in that as well. Another example is informing others, families, social workers of policies and procedures that are related to fair housing changes, related to housing changes within the home. Allowing a non-tenant to use a laundry room. For example, this will be maybe someone who has an in-home caregiver or someone who comes to their home to provide them with some services, maybe come to clean their home, etc., allowing them to use the laundry room. Moving from one unit to another without a fee, a reserved parking space, allowing a live-in aid. Occupancy standards are still to be considered there. And then also changing the rent due date. So for example, if I receive Social Security disability income and perhaps maybe I get my check on the 3rd Wednesday of each month, allowing me to change my rent due date so that that can accommodate me. And then also engaging with and utilizing the Ohio Relay Service. Reasonable modifications. So these are physical changes to the property to allow full enjoyment of the premises. And this can be the interior of one owns unit and then also common areas as well. So for example, a lobby that maybe perhaps needs a ramp to be installed. Reasonable modifications are typically at the tenant's own expense, meaning that the tenant has to be the one to pay for the modification. Persons can request again at any time. It doesn't have to be prior to them signing a lease with you. It doesn't have to be, within a year of them living there. They can make a request at any time when it's needed. Landlords, again, can require proof of covered disability. So if it's not readily apparent, you can request that proof of the covered disability. And then the modification, again, must be related to the disability. So for example, requesting a ramp, you have to have a covered disability with that. It can't just be because I want the ramp to be installed in the home. So some reasonable modification request examples: widening doorways, installing those grab bars, lowering heights of kitchen cabinets, installing a ramp, installing automatic water faucet shutoffs, installing or removing carpeting, lowering or raising height of switches, outlets, or thermostats, and then also installing lever door handles instead of the orbital ones that you typically see in older homes. So requesting a reasonable modification, a housing provider can, again, ask for proof of disability if it's not readily apparent. Also, a housing provider can deny a reasonable modification if it would cause an undue financial and administrative burden, alter the normal provisions of services, and not directly relate to the covered disability. In those circumstances, reasonable modifications can be denied. If those aren't met, then a housing provider does have to grant the reasonable modification. As a landlord, you can also require that the modification is done in a work-like manner, meaning if, for example, a ramp is being installed, that proper contractors are being used, proper materials, and things of that nature. And then also, a landlord can require that a reasonable escrow amount be established as well in order to restore the property. So for example, if it's going to be a huge cost to restore the property after this reasonable modification has been completed, then an escrow amount can be established where the tenant will then pay into that each month to ensure that at the end of their tenancy that they're able to pay to restore your unit. A housing provider, however, can't ask any questions about the nature or extent of a person's disability. Require the person with the disability to disclose their specific diagnosis. And so while landlord can ask for proof of the disability, it doesn't have to specifically say what that person's diagnosis is. All that proof would have to say is that this person has a disability that substantially limits one or more of their major life activities, and this reasonable modification would allow them to enjoy the unit equally. That's all it has to say. It does not have to give a specific diagnosis. It does not have to give any information specifically about that person's condition. A housing provider also cannot ask for medical records, and then also cannot ask how long a person has had their disability. So now that we have talked about some of the protected classes, we'll talk about some of the discriminatory acts related to fair housing transactions. So what is housing discrimination? It's refusal to sell, rent, negotiate, or otherwise make unavailable or deny a dwelling, discriminate in the terms, conditions, or privileges of sale or rental of a dwelling, or in the provision of services or facilities, make, print, or publish any notice, statement, or ad indicating a preference or limitation based on a protected class. And so let's go back to the refusal to sell, rent, negotiate, or otherwise make unavailable or deny a dwelling. So again, if a person, for example, comes to an apartment and they're looking for it, and the landlord states that it's available, say for instance, this is a white person that's coming to view the apartment. Then when a Black person inquires and they say it's not available, this of course will be refusal and violate the Fair Housing Act. Discriminate in the terms and conditions. So for example, requiring one person, say for instance, that they are on Social Security disability income, requiring that they pay a rent deposit 3 times more than what you would typically ask of someone. Or perhaps maybe someone in a wheelchair, you're requiring them to pay 3 times more of a rent deposit because they use a motorized wheelchair and you're worried about them scratching up the floors. This would be a violation of the Fair Housing Act on the basis of disability in that case. And then when making, print, or publish any notice, statement, or ad indicating a preference or limitation based on a protected class. So this is to be very careful when you are advertising for your apartments or homes or rental properties. You want to make sure that you are advertising the place and not putting any desired qualities of tenants in those advertisements, right? You don't want to say this home would be perfect for someone without children, or this home would be perfect for a married couple. You just want to describe the property and not the sort of people that you want renting your rental properties. More on discriminatory acts. Misrepresenting the availability. So again, stating that a property is unavailable when it actually is. Denying a reasonable accommodation or modification request. So again, just those three things to be aware of. If it is not causing an undue financial and administrative burden, if it is not a covered disability, and if it is not changing the provision of services, then that modification or accommodation has to be granted. And if if you do need to deny someone, you want to engage with the tenant in an interactive process to see what other resources may be available. You also want to be sure that you respond in a timely manner. And so there's no specific timeline for that. If a person puts in a reasonable modification request, and say, for instance, it's for them to get in and out of the home, you want to make sure you respond to that in a timely manner and not just put that off to the side. Even if it is to deny them, you still have to respond in a timely manner. You also want to make sure you document everything when it comes to reasonable modification and accommodation request. So once you receive the first request for a reasonable accommodation or modification, you want to make sure that you document that so you have a paper trail that shows when it was first requested and then also when you responded to that person. More on discriminatory acts. Intimidating, threatening, interfering with, or otherwise retaliating against a person who is exercising their fair housing right. So different circumstances may come up where a person maybe feels like they have been discriminated against, and they may try to bring a complaint against that. And until that issue is resolved, retaliating against someone by maybe perhaps saying that they have to move, or charging them more in rent, or not coming to fix repairs because they have made this complaint, is definitely then a violation of the Fair Housing Act. So you want to just allow the process to go forward and allow it to be investigated without retaliating against someone who maybe feels like their rights have been violated. So just quickly, some emerging issues related to fair housing. And so I want to touch base and talk about discriminatory effect standard when it comes to fair housing. And so housing practices with an unjustified discriminatory effect are those acts that are actually predictably with a disparate impact on a group of persons that create or increase or enforce or perpetuate housing discrimination patterns because of either their race, color, religion, sex, disability, familial status, or national origin. And so in Fair Housing Act transactions, you have disparate treatment. So for example, with me being a Black person, if you are denying me housing because I'm Black, that will be disparate treatment. But sometimes there are these discriminatory effects that happen called disparate impact, where it may be a neutral policy as it stands, but they have a discriminatory effect on one or more protected classes. And so we'll talk about some emerging issues that may have discriminatory effects on protected classes. So one of those includes criminal background screening. So HUD has issued guidance on criminal background screening as of April 2016. So criminal history-based restrictions on housing opportunities may violate fair housing laws if they disproportionately impact people in one or more protected classes. So for example, Black or Latinx people. So again, blanket bans saying just, flat out no felons, no misdemeanors, whatever the case is, those can have a disparate impact and are therefore unlawful. So when screening a person and considering criminal backgrounds, you want to evaluate an applicant's background on a case-by-case basis. You must consider the severity of the crime and also the length of time since the crime was committed. So for example, severity of the crime. Perhaps a person has a felony record, but it was perhaps maybe for them being in a car accident, hitting someone in the grocery store parking lot and then fleeing the scene. That may not be severe as someone having another felony record. Also, the length of time. A person may have committed a crime 20 years ago, but then if they haven't gotten into any trouble since then, considering that as well. So in order to be able to deny a person based on their criminal record, you must be able to prove through reliable evidence that that criminal history makes housing that applicant a risk for other tenants. So it can't be speculative. You have to have a demonstrable, it has to show demonstrable risk for that tenant when it comes to denying them. And so when conducting these screenings, it's okay to ask tenants for fees for background checks so that you can properly screen them and then determine whether or not they are eligible for residence in one of your rental properties. So the guidance that HUD issues prohibits landlords from denying housing based on an arrest record, blanket bans on anyone with a criminal history, and then conducting background checks inconsistently, performing them on some and not others based on stereotypes or fears. And so, for example, you allowing someone, a female perhaps with a woman with a criminal record for maybe an assault charge into your property, but then denying a male with an assault record. So you have to do it consistently. Further things that a landlord should consider is that consider individuals again on a case-by-case basis and evaluate the nature and the severity of the crime. Consider the length of time that has passed since the crime was committed, and then make a determination based on facts and evidence and not just a perceived threat. Another emerging issue that comes up that may have a discriminatory effect are criminal activity nuisance ordinances. And so criminal activity nuisance ordinances are local laws that punish property owners for repeated criminal activity associated with their property. These ordinances often focus on activities such as noise violations, animal complaints, assault, trespassing, and drug activity. And some are very broad. We have a high concentration of these sorts of ordinances in Northeast Ohio, especially in Cuyahoga County. And so a report that was done by Cleveland State University faculty and staff in 2017 titled "Who is a Nuisance?" indicated that criminal activity nuisance ordinances are often enforced by cities against residents that are victims of crime or in need of emergency assistance. So this might include a victim of domestic violence, someone calling for assistance because they are in a domestic violence situation. Also, people experiencing mental health crisis, group homes for people with disabilities, and then also people struggling with drug addiction or overdose. And so again, criminal activity nuisance ordinances typically penalize the property owners, and one of the biggest outcomes of property owners dealing with criminal activity nuisance ordinances are eviction for the tenants. And at that instance, when a tenant maybe becomes evicted because of these criminal activity nuisance ordinances, that can violate their fair housing rights. The city of Bedford has recently repealed their criminal activity nuisance ordinance after a a lawsuit was settled with the ACLU of Ohio. And so these are ordinances that typically can have a discriminatory effect, and it's just something to be aware of. So now that we've talked about protected classes and emerging issues and discriminatory acts, let's talk about the consequences and goals of fair housing. So, what are the consequences of violating the laws? Well, who can bring a lawsuit? Anyone. We are all members of a protected class. And so anyone can bring a lawsuit. Where can a case be brought? A complaint can be filed with HUD, the Ohio Civil Rights Commission, and local fair housing boards. Again, who can be sued? Any owner of residential real estate, builders, managers, lenders, insurers, zoning boards, cities, real estate agents. The list is not exhaustive. And then when it comes to remedies, actual damages, economic and intangible, civil penalties and punitive damages, injunctive and equitable relief, and then attorney fees and costs. And so in the instances when a complaint is brought, typically there is an administrative hearing after a complaint investigation. If after investigating the complaint, HUD finds that there is reasonable cause to believe that discrimination has occurred, it will inform all of the parties involved. Cases will be heard in an administrative hearing within 120 days. And then unless a respondent wants to be heard in a federal court case, then it is moved to there. In the administrative hearing, if the case goes to an administrative hearing, HUD attorneys litigate on a tenant's behalf, and then that is when it's determined what sort of remedies are given. So that's the process if a person brings complaint and feels like their fair housing rights has been violated. So the goals of fair housing: reverse decades of effects of discriminatory policies, foster inclusive communities, and then allow everyone equal access to the housing of their choice. Again, where you live is very important, and so fostering those inclusive communities are important as well. And then another goal of the Fair Housing Act is also to increase diversity in schools. So some best practices as we leave, something to leave with: design a non-discriminatory list of rental criteria. And this can really help in not getting tripped up on who you're deciding to be your tenant. So design a non-discriminatory list, check that list off as you receive tenants coming in, and then approve someone who meets all that criteria on a first come, first served basis, not choosing around or picking around. That makes it very clear and cut who you have determined based on the non-discriminatory criteria that you have established. So there's no case of discrimination that can be decided on if you are going off of that list and giving the first person who meets that criteria. So design that list when you are screening your tenants. Advertise your available unit, describe the property and not the people that you think that may be interested. Again, you want to describe your amenities in your property. 2-bedroom, 1 bath, has air conditioner. You don't want to say, good for people without children, in a neighborhood where there are Hispanic people. You don't want to describe anything of that sort that's related to protected classes. You just want to describe your property. Then if conducting a credit or background check, make sure you receive written authorization from the applicant, and then adhere to both the Fair Credit Reporting Act and Fair Housing Law. Review applicants in the order that they are received, and then approve the first qualified applicant. Remember, everyone with a disability has the right to request an accommodation and a right to a timely response. Document all requests for accommodation and modifications, even if it's a verbal request. And then again, Engage in the interactive process if the requested accommodation must be denied to explore alternative accommodations to meet the person's needs. So if you need to deny someone, engage with that person and letting them know that you have to deny, but then maybe sit down and think outside of the box of some other alternatives that may allow that person to still enjoy the unit equally. And then if you have questions about fair housing situations that you want to talk through, please give us a call. If you want to stay connected to fair housing issues that emerge, please feel free to follow us on social media, on Facebook, Instagram, or Twitter. Call us for assistance and then refer individuals to us if they have questions as well. And then for questions, again, you can contact us at the Fair Housing Center for Rights and Research. We're located downtown Euclid Avenue. Right now, we are all working virtually, and so you can contact us by email and the phone number provided right here, which is 216-361-9240, if you have any questions or would like to talk through some issues related to fair housing. And with that, I will end.
Tanisha, thank you very much for your very thorough presentation tonight. There was a lot of material there and a lot of good stuff. Diverse and accessible, a diverse and accessible community is important for a thriving community, and equal treatment of all our citizens in Lakewood is a high priority. Thank you for speaking on this topic tonight and explaining things as you have. Thanks very much. Our next speaker tonight is Christopher Parmalee from our Lakewood Building Department. He is the Assistant Building Commissioner in the Building Department. There's that handsome devil. He is the go-to guy in the Building Department on issues that directly affect you as a landlord and regarding your rental unit and your property and the compliance with your housing license and all kinds of things building wise. So Chris, the floor is yours.
Thanks, Director Corrigan. Some of you, welcome back. To the new folks, welcome to the community. We like to have you. So hopefully this is informative for the new landlords, the existing folk. More of the same as last presentation, added a couple nuances. So let's move forward a little bit. My name's Chris Parmalee. Some of you know me, some of you don't. Like Director Corrigan said, I'm the Assistant Building Commissioner, the Residential Building Official, and the Housing Officer for the City of Lakewood. I wear a lot of hats. My wife and I have been here since '09. We bought our first home then. I grew up here, grew up on Marlowe, went to the Lakewood schools. I have a proud graduate from Lakewood High. I have another one that's a junior this year, and our littlest one, Grace, he is at Grant. And we appreciate your investment in the community. It's a big deal. I mean, there's a lot of neighborhoods to invest in, and for you to choose Lakewood, that means an absolute ton to us, and we greatly appreciate it. So a little bit, these were provided from last census. We haven't got the information back, but there's a lot of this that hasn't changed. We average about 9,200 residents per square mile. We're the most densely populated neighborhood in San Francisco and Chicago. We're really tight. 32,000 housing units. The median value of 170,000. I think it's higher than that now. But like I said, these statistics are a little static right now. But 180 miles of sidewalk. That's why we say we're one of the most walkable communities. You can get to your and get a bite to eat. go to your favorite bar, go to the libraries. I mean, essentially, you don't need a car. You can get around anywhere on 5.6 square miles, condensed. A lot of people, not a lot of area, and we have 92 miles of roads, which sounds like a lot. So, whoops. Think about your interaction with the building department. You being landlords will interact with us throughout the years, be it upgrades to the property, questions. We're always available. Feel free to call us if you have any questions about anything. Exteriors, those are made for full-time property maintenance inspectors. So these are the folks make sure upkeep's made with paint, the exteriors, lawns, debris, keep a close eye and close watch on the neighborhood. And those would probably be the majority of the folks that you'd interact with, unless you were doing something that required permits and plans and such. And that's when you'd interact with our building inspectors. Safety and maintenance inspections. Once you have a rental property in the city and maintain your housing license, you're put on essentially a list for inspections. Those are safety and maintenance inspections. They're for the interior from attic to basement. These inspections aren't any state building code, plumbing code, mechanical code, electrical code. They're all based out of our codified ordinances. We call it a safety and maintenance inspection. When we do these inspections, we do have inspection sheets that you can get from the building department that kind of shows you what we're looking for. It's not all included, but it gives you a pretty functioning windows, functioning doors, peeling paint, egress, ingress, stairways, handrails, smoke detectors. I mean, some of us think it's common sense, but a lot of people just don't know what they are to require and what would actually constitute as a housing violation. When you get information about a safety and maintenance inspection, you'll get a inspector in the mail, giving you your inspection, which are typically 10 to 14 days out. It gives you time to prepare in case you did have a couple little things you needed to get done before we show up. If you can't be there for any reason, you'd let us know. Anybody over the age of 18 is allowed to let us in. Your tenants can let us in to conduct the inspection, and you would be required to give your tenants notice in writing 24 hours prior to our arrival. So usually somebody will post it on the entry door or in a common area, something like that. Now for 1, 2, 3 family homes, we're doing the whole residence top to bottom. When we start talking anything over 10 units, if you have an apartment building that's got 60, 70 units in it or something like that, we do 10% of the units, and as long as the inspections are kind of following suit, nothing crazy, we cut it at the 10, and then the common corridors, laundry rooms, et cetera, et cetera. If we do feel that we're finding more and more and more as we go, we will ask to get into more and more units. So just because we say 10% doesn't mean you notify, the 2 on the second floor, 1 on the third, and pick, the pick of the litter essentially. You would post that on each individual unit, just so in case we had to get in there, that tenant's been clearly notified. Some of these protocols have changed. Obviously, we're going through it right now with COVID-19. We're all adapting. We're all doing things a little different. With the building department, we've opened up a lot of online activity. But with that being said, the safety and maintenance inspections kind of took a pause for the rotation, because a lot of people don't feel comfortable with folks being in their properties, but that doesn't mean that we won't inspect, I guess. So a little further down the line, that'll make a little bit more sense. So the certificate of code compliance inspections, a lot of folks know them previously as point of sales. Anytime you own rental property in the city of Lakewood that is a licensed rental, you go to sell that property, you need to have a CFCC, certificate of code compliance, otherwise known as point of sale, which is essentially the same as a safety and maintenance inspection. We do the inspection, we draft the correction notice letter with, the eighth, whatever that were on there, the safety and maintenance. We provide that letter to you. You would in turn, if we have the buyer's information, which we usually do, we CC them on it. You folks kind of talk about how you want to handle it. The landlord, property owner, they can take care of the violations, or the buyer has the availability to assume said violations, so that they're essentially quote unquote on the hook, and we'd follow back up with them. Sale goes through, everything's good to go. Again, with those certificate of code inspections, they're currently on hold because of COVID. So when you sell your rental property, as of now, you're not required to apply for a certificate of code compliance inspection, but it is your responsibility, as well as your selling agent and the buyer's agent, but this kind of, the ball's in your court with this. Make sure you and your agent provide the information to the selling agent, or to the buyer's agent rather, I'm sorry, that if this property is to be used as rental property again, they, by codified ordinance, have to obtain that housing license. So we have, cover the housing license. If you have plans to submit, you'll drop them off at the building department, new hot water tank, furnace, anything like that. You'd get permits, you'd interact with us. That housing license, we kind of covered that. Like I said, rental Lakewood, you are required by codified ordinance to have a housing license, and it is your responsibility and your seller's responsibility to notify the buyer and the buyer's agent of such. So we just talked about not going in the house because of COVID, so let's talk about going into the property. Your tenant calls us with a complaint. Every complaint that comes through, we look at it as valid, and we do respond to that complaint. If your tenant calls us with a complaint, we don't have to notify you that we're showing up to the property. That's not our responsibility. We're going out, we're taking a look at what your tenant has to say. We'll evaluate, if it is a safety violation, and go from there. If it is, we draft a correction notice that would go to you being the property owner, and you would correct those violations within a timely manner. A lot of times these complaints, not a lot, but there's complaints that come through. If there's a rift between you and the tenant, or you're in the eviction process with that tenant, we've got many calls from tenants getting evicted, and now they want to run us through, the basement, their unit, and they want to point out everything that's wrong. We have to respond to those. It's no different than a normal complaint. The tenant can call and file a complaint regardless of the relationship that they have with the landlord. Last but not least on this slide, keep your grass cut. Stop by your properties, once a week, once every other week. Just take a drive by, make sure the outside appearance is the way it should be. Grass is cut, sidewalks are shoveled. That's a big deal. Like we just talked about sidewalks and the walkability of the neighborhood. It's important. It really is. I mean, we have a series of grade schools, 2 separate middle schools, the high school, and these kids are walking from everywhere. And it's not just the kids, it's the people walking their dogs out for a walk, the pizza guy, anybody. So let's keep the walk shoveled. And like I said, stop by your properties, take a look at the grass, make sure there's not garbage laying everywhere. I feel that I don't know how many calls from landlords that say, oh, I didn't know anything about this. I haven't been by there in 2-3 months. I've talked to people that live out of state that bought the property sight unseen. If you're an absentee landlord, meaning you live outside kind of the general Cleveland area, you're out of state, you, per the codified ordinance, need an agent, property agent to, maintain that. We need somebody to call if there's an emergency, somebody to reach out if there's a fire. So you need to have a property maintenance agent if you are an out-of-state owner or live far away from the Cleveland area, down south, Columbus, something like that. But this is your property. This is your responsibility to maintain. And we just ask for your compliance to do so.
Hey, Chris?
Yeah.
A point of clarification, the housing license, is that a annual obligation of the landlords to apply and to obtain a housing license?
Yeah, the housing license, we're going to cover that a little bit because there's some things that have changed with processes. But yeah, the housing license is an annual license. They are due November 1st. They have been due November 1st since housing license season in 2019. City Council voted to make the commercial and residential licenses all due on the same day. It used to be they were divvied up between spring and winter. Now it's November 1st. Hands down, that's when they're all due, and they're non-transferable. They're not prorated. If you buy the house in October, you have to secure your housing license, and we'll give you till the November date. But if you were to buy in April, you'd have to secure the housing license and then secure another one before that November due date.
Okay. And if they have any questions, pick up the phone and call you and
know where to find us. 216-529-6270. That's our main line. We just because we're working remote, we're in the office at kind of every other day to keep that important separation. Everybody's desk phone rings through to their work cells. We're accessible. It's really hard for us to hide, and we don't, because there's a lot of important questions that people call and ask. All non-owner occupied, single family, 2-family, 3-family, multifamily, being apartment buildings and condominiums, as well as vacant properties, are required to have a housing license. If you occupy one of the floors of a 2-family, you're not required to have a housing license. But if you occupy a floor of one of the 3 families, you still need a housing license. You just don't pay for the dwelling you live in. Vacant property licenses are important. If you have a property that it's going to sit for a while that you purchased, greater than 6 months, if you were willed a house, left a house, you not sure what you're going to do with it yet, it's going to sit there for a while, that vacant property registration license gets that property essentially on the radar that it's vacant. So if there's some sort of a break-in, house fire, something like that, we can notify first responders, and then they will have your contact information to reach out to you. So that's really important. Housing licenses, as I stated before, starting in 2019, expire November 1st, and are non-transferable, and they cannot be prorated. So that's the rule. I mean, if you call and ask for it to be prorated, we're going to say we can't, because it's not in the ordinances. Housing reminders, late fee notices. If you've had rentals in the city in the past, you're used to getting, something in the mail, usually 3 or 4 times before they're due, and then the late fee notice. We are not sending paper correspondence out anymore. It's very expensive to pay that postage for all those correspondences, especially when you have, roughly 3,000 housing licenses in the city. It adds up. But how you will be notified is via email. This year we sent 5 housing license reminders and 3 late reminders via email through our automated system. It's very efficient. It saves us time in the department. And now, especially because of COVID, I mean, everybody's connected electronically. On your application, if you do not provide an email address, you won't be notified. Depending on your email provider, SBC Global, Yahoo, Gmail, it could go to your spam mail. So periodically check your spam mail, check for emails from the city of Lakewood. If you see if you see one in spam, make sure you mark that it's not spam, so it hits your normal inbox. Again, late fees are assessed after November 1st. So let's make sure, put it on your calendar, set a reminder on your phone. We will notify you several times. They're due November 1st, so we usually start sending reminders out in September. 1 every 3 weeks or so. So keep an eye on that email or set yourself a reminder. Please post your housing license in a visible area, common area, front vestibule, front entrance. And when you do your application, the required fields show you what needs to be filled out so that appears on your license. If you do decide to sell your rental, again, you're responsible, your agent's responsible to notify the buyer that they will need to secure a housing license if that property will be used as a rental. If it's not to be used as a rental, they're not required to have a license. Down at the bottom of the slide here, our codified ordinances 1306-43 through 53 has additional requirements and information, all based on what we just discussed on this slide. A little bit of refresher for the housing license change. All housing license applications are completed online now. We do not have paper applications. They don't exist. So if you were to call and ask for a paper application, we won't be able to provide you one. So the folks that this is a refresher are pretty savvy with our new system. The new owners, you'll see a web address in pink there, citizenserve.com/LakewoodOH. That is our customer facing portal. You go on, you create a user account just like you would with Amazon, Target Online, anything like that. It's pretty intuitive. You're gonna, once you create the account, you log in with your credentials that you just created. It's gonna send you to a home page. There's gonna be a picture of a house with a for rent sign. That's where you go for the housing license. If you're a new owner, you're going to apply for a housing license. If you are an existing owner, you're going to renew your housing license. Once you apply for that housing license, if you applied this year, you're going to have an HL21 number. That HL21 prefix follows you for the entire duration that you own your property in Lakewood. HL21 doesn't turn to HL22 in 2022. That stays the same. So it's imperative that when you go to get your housing license for next year, you don't apply for a license, you want to renew. If you apply for a new license, it essentially creates 2 licenses in the system, and it can get a little confusing. We can clean it up on our end. Mistakes happen, but be sure if it's a new license, you want to apply. If it's a renewal, make sure you select renew. You're going to go through the fields. It's going to ask you, If it's do you have a 1 family? Do you have a 2 family? It breaks down to different categories. So single family, 2 family, 3 family, multifamily, condo, and vacant property registration. Your condo is not a single family. Your condo is a condo. Single family is a standalone dwelling. If you have any questions completing the application, you can always give us a call, 216-529-6270. You call that number, you have about 14 phones that start ringing. So somebody's going to pick up. We will help you. If you're not savvy when it comes to technology, you don't have an email address, there's a lot of folks that have owned properties in our community for 40, 50 years, and they don't have access to the internet. We do have kiosks set up in the building department. We are closed to the public. We will take appointments. So if you were to need to schedule an appointment to come in and possibly use one of our PCs, we can arrange that. You would be required to sign a visitor's form, wear your mask at all times. Everything's disinfected. We do take care when it comes to that. Or if you get jammed finalizing the application, again, 529-6270. If you're in front of the computer and you need some help and you're at home, one of front office staff, Mike, Kelly, or Diana, will be more than happy to help walk you through that process step by step. You can submit your payment online through the portal. If you don't want to do that, you can call us and we could take payment over the phone. You could send a check as well, but if you send a check, please make sure it has your housing license number on it. That's how we're going to reference that. If you have any questions about any of that, those processes, please give us a buzz. Housing license fees to the right of your screen. Non-owner occupied condominiums, those are $45 per unit. The condo associations used to cover those costs as a whole. They no longer do that because the codified was changed to reflect this. So $45, that's annually. Again, everything expires November 1st. Non-owner occupied 1 or 2 family dwellings, $75 per dwelling unit. So that would be $75 for a single, $150 for a 2 family. 3 family dwellings, $60 per non-owner occupied unit. So if you live on the 3rd floor, it's $120. If you rent out all 3 floors, it's $180. Any payment made after November 1st, again, we'll have a late fee associated with that at $25 per dwelling unit. And if you have an apartment building, like I stated before, it can get really expensive really quick. So we want to make sure that we notify you to get that taken care of before November 1st. Nobody likes spending money they don't have to. There is a limit of $3,500 for any occupied structure with a single license, be it large apartment buildings. Those max out at $3,500. And again, we spoke about the vacant property license, $200 per structure per year. Next slide. So this went primarily fast this evening. Some quick resources and quick links. CitizenServe, again, our online portal. The web address is there for you. Residential Code of Ohio, that web address below, it's a free website. You can get access to the Residential Code of Ohio, the Ohio Building Code, Plumbing Code, Mechanical Code. It's all there, it's all free. We don't expect you to dive in and start reading the legalese. But if you have questions, in regards to the building codes, you'd go there. Our City of Lakewood zoning codes, it's that address right there, that amlegal.com. That can get you the whole array of zoning codes. I think what would more or less interest everybody on this presentation tonight is that 1306 chapter. That's everything that's anything to do with property maintenance, safety maintenance, safety and sanitary, things like that. As Judge Carroll spoke before about evictions, that's handled through the courts. Please do not call the building department with eviction questions. We're not lawyers. We would advise you to seek counsel or have you call the courts directly. Our building department, Monday through Friday, 8 to 4. Phone line opens up at 8. Feel free to call us at 529-6270. I can be personally reached at 216-529-6295. You could email us at housing.building@lakewoodOH.net. The completion form for the online training that's tonight follows that right there. So it's some good information. And if you have any questions about anything, I mean, not just your rental property, but maybe do's and don'ts, you have construction questions, you have some, building stairs or whatnot, that's how you can reach us. That's the end of the presentation. I appreciate you dialing in remote with us tonight. And if you have any questions, feel free to give us a call.
Chris, thank you for that presentation. We appreciate it, and encourage everybody to keep the properties up and get those housing licenses. Our next speaker tonight is Lou McMahon, and Lou McMahon. Lou is a lawyer that has been retained by the city of Lakewood, and Lou has been is and has been in ongoing talks with the U.S. EPA and the Ohio EPA over our compliance with the Clean Water Act and our managing of the storm and sanitary sewers as they relate to both Lake Erie and the Rocky River. And as Chris said, with over 92 miles of roads in Lakewood, you can imagine the over-under sewers that we have that all run under our roads and down into our wastewater treatment plant down in the valley. Substantial investments have been made to our over 100-year-old sewer system and our wastewater treatment plant located in the valley. Much more work is required to be done, and much more work needs to be invested over the next several decades. Lou's presentation will be an introduction into what has been and what needs yet to be done. At the end of Lou's presentation, a code will appear. Please fill out and submit the form attesting to your attendance today, and submit it on the city's website in the link that Chris just referenced there. You will be in compliance with everything, and we look forward to Lou's presentation. So here is Lou McMahon in his presentation regarding the U.S. EPA and our sewer system in Lakewood. Thank you.
Well, then we'll get right into it. Thank you, Mayor. Thank you, Mr. President. Glad to be back in front of everyone to give an update. I think the last council meeting where I actually talked about this was the last in-person council meeting before COVID canceled them back in February of last year. So tonight we're going to give, as the mayor mentioned, we'll give an update of what's been going on. We'll touch briefly about where we are with US EPA, and then we'll talk about one of the important aspects that's a required part of our integrated wet weather plan, and that's looking at our rate structure. Obviously, this is going to be a very big financial commitment and undertaking to do the plan that that's already been approved, and we're going to have to look at what's equitable and efficient ways to raise the funds to pay for that plan. So we'll talk about that, but this is just going to be an overview. There are going to be more meetings on all these topics other than the update specifically, and there'll be more specific proposals coming to you. But this is just to refresh everyone's recollection and bring you up to date to where we are, and to bring our public up to where things stand as important questions come forward in the next first half of this year here. So if you have questions, I can talk faster, I can talk slow, and I can talk sewers all day long. Raise your hand and glad to address them here. Otherwise, I'll just step through the presentation. So hopefully this advances things. There we go. Okay, so here's the agenda for the presentation. Just to give you the overview of the introduction, we're going to talk about our integrated wet weather improvement plan, a little bit of the background, because people often forget, if they don't think about sewers all the time like we do, that, you know, what our situation is, what this plan is, then how we had arrived at what we did and what we're required to do. We'll touch on US EPA and what's been going on there, and then a little bit more on the rate structure as an overview, as I mentioned. I want to point out for anybody who's watching, and for all of us, though, our Lakewood website has a tremendous amount of information that's on it, and we try to be very inclusive in the information that's available. Going back to developing the Clean Water Lakewood plan, we tried to reach out to people, solicit public comment, and make sure the information was there for people, and continue to do that. So just to point out again, if the plan itself is on the website, there's actually the phase 1 plan that we had to do a couple of years ago, and then the phase 2 plan that we submitted just in March of 2019 is there. And that's the one, it's 10 chapters plus 3 volumes of appendices, so 4 big binders worth of information that were current then. It's a very detailed review of our situation, our plan, what we intend to do, what we have to accomplish, and including a long history section that's in there. So anybody who's even just coming brand new to this issue has a full resource to be able to address you know, their concerns, and find the information. It's complex. I won't say it's easy, because there's a lot of it, but hopefully it's well organized and it's all there. We have on the website also our overflow map that tells you the status of when our overflows are overflowing. It's real time. So if you go and you see, it'll light up which ones may be activating. This is something that's actually required by federal law for the Great Lakes, but Lakewood's got a great tool. It's very important for people who, you know, recreational access in particular of our lakefront properties and riverfront properties, and people who access the water there. So that tool is on the website and should be active 24/7. Obviously, not a lot of people on the lake these days, but you know, we try to promote it as much as we can, and that use is expanding. That's a lot of background and overview. Now to talk about what we've been doing in the last 2 years since the plan was adopted. This is some background. It's actually in the I think the plan itself, and we certainly used it. But Lakewood's always continuously invested in improvement of our system. We've never slowed in the progress that we had. And this has been an important feature for regulators, that they've seen the progress and that we deliver on things. So spent $60 million, that's probably the last 12 years now, and raised our capture of the wet weather flow and the ability to treat it from 79% to 85%. That's an important number. There are a lot of communities that are spending billions to just try to get to 85% control. There's something called the CSO policy, which is part of the Clean Water Act, has a baseline of compliance of at least 85% capture and control. But we're on Rocky River and we're on Lake Erie. Both of those are declared to be sensitive areas because of the recreational use of them by the state. So we have to look at higher levels of control. Just by comparison, Northeast Ohio Regional Sewer District is going to achieve something like 98% control of all their wet weather flow. And that's because of being on the sensitive water bodies. So we're looking at the same thing. The big high rate treatment project down at the near the plant, it's not part of the plant, but it'll control CSO 002. That will raise our percent capture to 88%, which is a great step. And like I said, anything that we can get through the interceptor that can get down to that area, we will be able to treat through the plant or through the high rate treatments, which we used in wet weather times. And then our IWIP plan that we have, those 2 5-year blocks that I showed you, plans to invest an additional $50 million on those next 2 big projects. I think when we get through CSO 059, that project at the Gold Coast, as well as the CSO 052 project, that then will be, we used CBOD, one of the pollutants in sewage. We've used that as a tracer. And we'll be getting 95% of the pollutants that come from our system captured and treated. So it's a big investment, but we've put the best bang for the buck in terms of public health and environmental improvement up front. And that's something the regulators have found very attractive about our plan. So these are the investments, again, where we spent some of the money. This is a picture from a couple of years ago because construction's gone far beyond this, but the high rate treatment is 23 million, maybe construction costs. You see that's number 1. Number 2 in the upper right-hand corner, this was a project we did. We did an aerial sewer and brought some of the West End neighborhood over, and there were 2 permitted CSOs that took care of that no longer overflow to the Rocky River. We had 3. We had the big CSO 052, we'll talk about that. We had 2 smaller ones, one of which got flow from the Rocky River neighborhood across the river that's tributary to our system, and some from our own West End system. And one of those, we eliminated the overflow, so it can't overflow to the river again. Another we've controlled except for extreme emergencies, maybe something that's like a 25-year recurrence interval storm, that it would overflow. So that's 2 out of the 3 off the river that we've taken. And the river in many ways is more sensitive because it has less flow, less assimilative capacity than the lake does. So this is progress we've made without being under orders from anybody. This is how Lakewood's gone about its improvement and how we put it in our plan. This is another picture. The high rate treatment is expected to be completed ahead of schedule. This is from 2020, so you can see it's moving there. We expect it to be online way ahead of schedule and give us time to do some shakedown. We only have to construct it by maybe September 1st of 2022. But we've been very diligent in working ahead to have float in case anything came up, any issues came up. And that's one of the things when we do talk about any schedule, that we make sure we maintain room for the unexpected, like a pandemic or specific site conditions or anything else that we run into. As you can imagine, whenever you open anything up, just like in a Lakewood house, if you open up the wall and look at the plumbing, you don't know what you're going to find. Things weren't necessarily uniform, and you have to be prepared for unexpected things. The same is true when you open up our streets and our system. We've done a lot of investigation, but when it comes to constructing new and retrofitting, there are always challenges. So we like to keep a lot of float time in there. This pilot study project, there's been a lot of interest. Actually, there's a lot of interest in Lakewood's IWIP. I've presented on it and others have presented on it, and it's drawn a lot of inquiries from people about what we've done. And this portion of our work has been very interesting because there's a lot of theory of what, if you went house to house and connected things in a modern way, what benefit would you get in the performance of your sewer system? That was the whole point in this pilot that we did in Atkins and the streets around it. And there will be a report coming out soon, but it was a very intensive effort to see if we do source control, if we hook up these houses correctly so that stormwater only goes to stormwater pipe, and doesn't find its way into the sanitary on private property. And then on all the public sewers, make sure they're tight and don't have cross connections as best we can. And where they're over under manholes or single manholes, separate the manholes so they don't have a chance to communicate between the two pipes. What will you get for that? And so this is actual real data in real world, and there's results. And filling in a gap in the whole industry that's trying to figure out how effective this can be. So it's time consuming, and there are places it's going to be cost effective. It's in our plan. Where a different solution like larger pipes are catching it, or like the storage solutions we have are going to be more cost effective. So this, you'll see a final report on this coming up in this half of the 2021. Here's another example, and this one actually is a great example of the integration that we've been doing, integrated planning in action. So we combined with the first phase, the first half of the Lake Avenue resurfacing project, a stormwater project and some other work. And you remember Lakewood Park was torn up for a summer. Well, between that and the new storm sewer that was part of the regulator projects, you can see the improvement that's happened. So this is CSO 058, which comes out right there down below the gazebo at Lakewood Park. And we had a lot of events, 64 events. It's like every other event means smallest rains almost are, this thing was discharging. And, but look at the improvement that we had. 2020, I think we ended up with 3 events, and that volume of 0.3 million gallons is minuscule. These are just really small events. And this is just based on being able to have a model and a plan that we knew when we were tearing up the street that we wanted to do these sewer related projects, both storm sewer and connections from the sanitary to achieve these results. So this is the benefit of having the plan. It was cost effective, that we weren't tearing up the streets several times. Besides the intrusiveness to the neighbors, everybody hates that. So this is a great success. And you know, there may be a little bit more work we have to do here, but it's to our benefit to not, you know, CSO 057 and 058 are on either side of Lakewood Park. And of course, that's where so much of our public engages with the lake. And, you know, this is where we want to see improvement, and we've seen it already. These are, this is a depiction of just those 2 other big projects. The CSO 52 is there, that, again, that dot at the corner of what you can see is Madison and Riverside. That's one of our biggest overflows in volume and frequency. The things that come from that whole southwest corner go down the Madison sewers, and the proposal is to build an aerial sewer and take it across to some significant storage, probably 3 large storage tanks on the plant property next to the plant. And then when the storms are over, the plant will treat that. CSO 059 is the Gold Coast. That's the project right behind it. And that's pretty much at the front end of the interceptor. So the idea of all those other mustard colored dots, the overflow locations across the lake, some of those are storm sewers. The idea is to push all that into the interceptor that we have, and that the only place that flow will come out of the interceptor, if we can get it there, is at 059 or at 052 or at 002 down to the plant. Anything we can push to the plant, again, goes out the goes through the high rate treatment. So the idea is sort of tighten up the system and deal with it at each end. The 059 will have storage that if, and you know, storms up to I don't know, maybe a 2-year storm or up to getting 0 per typical year. We don't know yet. We have to design it, but can hold all that flow for that time. So we're not discharging except in the very largest storms. And I should mention, again, US EPA has not gone away. They sent us a draft consent decree back in 2018. They've been very interested in our plan. I know Mayor Summers talked about when we went to DC and talked about our plan and what we'd like to see. They have their policies as to when you should have a consent decree, when you shouldn't. I can tell you, we've been talking with them. They really have identified that Lakewood's plan and what we've outlined is the right path forward. So we'll be in conversation with them continuing for a while. We frankly expected to hear something more detailed in the second half of 2020, but COVID pushed that. But you should expect that we'll come back to you when we hear from them on a possible, I'll just say a possible consent decree or other orders. And there are some benefits to that, as I mentioned, under the Clean Water Act. If we do have orders, you do have protection from citizen suits and third-party suits. That's part of it, as well as meeting other obligations. But they've identified, I mean, we've had US EPA here in tours, we've had Ohio EPA, and they're like, you guys know what you're doing. This makes sense. And I do this for a lot of communities, and I don't often hear those words. All right, so on to the rate structure, which there'll be actually much more coming up on this very soon. But we had it as a part of our plan. This is in the IWIP itself. This is sort of a capital needs for just the sewer program projected out. And as you can see, with the big projects that we have, 2023, we have council has approved rates through 2023 that fund what we have before us already. That's another thing that the regulators have seen as an extremely strong sign that of Lakewood's commitment. So the question will be coming up in 2023 and after, what is the appropriate way to structure our rates that pay for this? What's equitable, what's appropriate for the utilities that we have? How do we meet these needs? And you can always understand that as things like COVID happen and other things challenge our affordability, we have put in our plan the ability to raise those questions again. So we do everything we can to not have fixed dates for a whole program that's going out 25 years or something like that, but to integrate this with our other work and to be able to check in on our affordability. Our current rates are just based on, as they always have been, on water usage. We had the increases approved through 2023, and that funds the high rate treatment and the other things that we have to date under our plan. But we're going to need additional rate increases, and the structure of those is going to be really important. So we have ongoing IWIP needs, a big project. We also have a very old system, and we have a extremely well-run and well put together plant that needs continuous investment as well. So those are things that are going to require more funding in the years ahead. So we put rate evaluation in as part of the approved plan. And this is what we're going to be talking to you in more detail coming up, but this is just sort of an overview of what the issues are related to that. Some of the things, we try to use the benefit of time to maybe get some things started so that, you know, one of the great benefits of rates is if they're predictable and small, maybe going along with the rate of inflation and close to that. The communities that get in a lot of trouble are ones that rates jump and spike all over the place, 10%, 15% increases, then nothing, and then 10%. And that really is a problem for the rate paying public and for, you know, people trying to budget and invest in their properties. This is the key fact for utilities across the country. Our rates are based on water usage, but right now, water usage has been declining 2 to 3, and last year 3.4%. Actually, it was more last year, but as an average, the past 20 years, we have smaller household sizes. We have water efficient fixtures, and people are conscious of it. So from a utility standpoint, you can increase, say, your water rate, but you're not 5%, but you're not recognizing a 5% increase in revenue. And this is an unstable way to plan a long-term program. This trend is not going there. The other component of it is our costs on the sewer side are wet weather driven. They're not based on how much water comes from the tap and basically is flushed. Our costs are being driven by how much runoff is going into our sewers and the overflow we have to control in wet weather. And so if you have just a rate based on water usage only, those with large parking lots that don't use a lot of water are, it can be inequitable in that sense of not being able to, what the driver of the cost is not being addressed. So part of looking at maybe an impervious fee, some communities look at just a fixed fee for the cost of service, just for having an account, is to balance it. So you're not dependent on this very risky trend here. These are some of the different fees that we've been looking at. We don't have a proposal to say, but to put before you, but these are commonplace now in industry. A fixed charge just for having service connected to you, to your property, is one way that communities cover some of the fixed overhead that they have. Some of them have uniform volume rates, some of them have tiered rates depending on where you live. The bottom left-hand quarter, the impervious area charges, and these are very commonplace now. The sewer district famously has a separate stormwater fee from their rate structure that addresses their CSO program. And that is based on an impervious area charge based on how much parking lot and structure that you have on your property. And that goes to the wet weather aspects. In their case, it's to manage the regional stormwater system. But Columbus has it, Illyria's had it, Avon has it, North Ridgeville has a program. These are very commonplace now, highly defensible. So in summary, we've been making good progress. There's more to come to all of you on several of these fronts, particularly on the rate reform proposal. It's coming in the very near term, and then very soon we expect probably to be in position to be talking to you about what US EPA and Ohio EPA want to do with respect to an enforcement vehicle. I think that's all I had. Was point everybody again, or if anybody has questions to you, I'm always available anytime to talk to anybody. But there's an awful lot of information on the website as well.